This is a card that actually somebody had given me probably about a year ago, and I've been trying to think about how to work it in for about a year. And I think I did. But you know, in addition to some humor on this card, this was a postcard that was actually sent for some online service from the United States. So it has nothing to do with Rhode Island. But I think that some things with this card are great to demonstrate, and I think this card also has some faults, obviously. One of the things I actually like about this card is that it shows what the redactions are. We've seen some instances where records have been requested, and rather than redacting or blacking out what has not been provided, public bodies will either delete the information or white it out, so that it's really impossible to tell, or very difficult to tell at the very least, if information has been redacted or not provided, or whether the information was never there. If you're going to withhold or redact or not provide certain information, you need to make clear that that information has been withheld. The public may not have a right to the information, but they certainly have a right to know that certain information has been withheld, and they have the right to challenge it. So in this manner, this card obviously does that very well. It's very easy to tell the type of information or that information has been withheld. The previous slide also talked about stating a denial or stating a reason for each exception. And we've seen in certain situations where various parts of the record will be denied, and a type of general exception will be cited. And we'll talk about the exceptions in a minute, but you know, A1. If A1 governs the entire card, because it's identifiable to a particular person or employee, that's fine. But we've seen situations where part of the card or part of the redactions may be justified by one exception, other parts may be justified by another exception. You have to cite your justification for each exception. So be aware about that going forward. And the other part, and I guess it's debatable whether this card achieves that or not, is that the public record law requires documents to be provided that are reasonably segregable. So in other words, if part of a record is exempt and part of it is a public record, you have to provide what is a public record. You know, I guess it's arguable whether or not this card does that, but to some extent it certainly does, so I want to make sure that that's clear.
Prior to providing public records, the Access to Public Records Act also sets up some procedures that must be followed. Before they provide the documents, the public body must provide an estimate of charges and provide it to the person. And upon request of this person, they must detail the itemization of the search and retrieval costs, which should basically estimate the amount of time that they think it's going to take. And they must perform the search and retrieval in a reasonable amount of time. There's another provision at the bottom that you'll see, which is to provide reduction or waiver of search and retrieval costs upon a court order. We get a lot of calls and letters sent to our office asking if we can waive charges for not only us or other public bodies, but we don't have the power to do that, only the court does. However, if the public body wishes to waive these charges, they should feel free to do so. Some of the charges are set out in the Public Records Act, and in fact, we are very strict when we interpret these, and these are the charges that can be charged for and really nothing else. They basically boil down to 15 cents per copy on common or legal-sized paper, $15 for each search and retrieval hour, without being able to charge for the first hour, and no more than the actual reasonable cost of providing electronic records. And as everybody starts to use email more and documents start to be on PDF format or otherwise, it becomes much easier to provide documents this way. What this might mean for a public body is that it has to provide a lot more documents free of cost, because the amount of time it would take to attach a document to email and send it is going to be minimal. Now, of course, if this is going to be a very voluminous request, it's going to take several hours, then they should feel free to use the same procedures as long as that first hour is free and $15 after can apply. Mike talked to you a little bit about redaction. We saw several slides back. And in fact, the Public Records Act does place a duty on page 11, 382242, that there's a duty to redact and provide portions of a document that are in fact public record. Well, this has been coming up more and more, and this can be a very time-consuming procedure because, as Mike told you, not only do you need to take out portions of the document that are public, but you need to tell the person what has been taken out and the reason which you are taking it out. So this can take a great amount of time. The Rhode Island Supreme Court examined this in Bear v. Gannon, and they said that the cost of redaction should be borne by the requesting party. So if you're a public body and you know that it's going to be a voluminous request and you're going to have to do a lot of redaction, you should figure that into your search and retrieval time and provide it in your estimate.
Every person has the right to inspect and/or copy records, and you see that we italicized and emphasized the inspect and/or copy. If somebody wants to just inspect records, they have that right. If they don't want the copies, they can just inspect. The first case here, the Town of Barrington case, that was a case where Mr. and Mrs. Black sought access to certain tax evaluation records of the Town of Barrington. And there was some back and forth as to whether or not there were copies, whether or not there were inspections. But at some point in this case, it becomes clear, at least to us, that it's a request for it to inspect. A lot of times, whether somebody wants to inspect the records or not, or wants the copies, whatever their motivation may be, they do have that right. These cases are going to basically fall into two lines if somebody wants to inspect the records. The line that the Town of Barrington case fell into was that the records that Mr. Black wanted to inspect were all public records. There was nothing, at least based on the finding that we issued, there was nothing to suggest that there was anything in those records that had to be redacted. So in that case, it may very well be a situation where you can just provide access to those documents. The other line of cases is, let's just say for the sake of argument, that those evaluation records had Social Security numbers on them, or there was some type of information that had to be redacted that could not be made available to the public. In that type of situation, you may have to redact that information out, make copies, and then provide access. I think it's an open question as to, in that type of situation, whether or not you could charge for the copies in that scenario. We haven't addressed that, the courts haven't addressed that, so I think that's an open issue. And obviously the factual permutations, whether somebody's using the records, there are a lot of different scenarios of ways it can go. But as a broad matter, I think you're going to fall into those two categories. As a practical tip, I can't tell you the number of documents that we've seen, that we reviewed, that have been redacted, and you can see right through the redactions. I mean, it's almost humorous that we're deciding a complaint that something's been withheld improperly when you can see right through it. But if you're going to do that, the practical tip that we've learned, if you redact it, when you make a photocopy of it, if you turn the density of the image, you darken it all the way, that typically solves a lot of the issues. So now you get the law here, you get some practical tips. One of the issues that we also get a lot is, yes, we have the record, but we didn't create it. Somebody gave it to us, it was sent to us. The public record law is pretty clear. It's actually on page 11, towards the bottom in the bound book. And it makes clear that the public record law concerns all records maintained or kept on file at any public body. So it's not just documents that you create, it's documents that you have. So that's an important distinction going forward, an important point. And the Lincoln School Department case, this was one of the examples that we talked about earlier, where information was provided through a response, but the documents weren't provided. And we found that violated the Access to Public Records Act. In the bound book, at the top of page 12, you see 38-2-3F. There's no requirement to reorganize, consolidate, or compile information or records that the public body doesn't have in that form. The exception is if they're in an electronic format, and doing so would not be unduly burdensome to the public body. A type of spreadsheet, for instance, or a type of program that can be run to bring out some information. And you see the next slide. I don't know if we've really talked about this at prior Open Government Summits too much, but in addition to the right that the person has to inspect and/or copy documents, a person also has the right to receive any documents in any type of media that the public body has the ability or is capable of providing them. And the Energy Resources case was an example of this. The Office of Energy Resources was, applications were being made to that office, and based on the evidence that was before us, it seemed like most, if not all, of the applications were being sent electronically.